I want to talk about 3 reasons why you must never fail to tell your lawyer everything. In a criminal procedure, your lawyer, your representative, they are there to tell your side of the story. They are there to give your perspective. They are there to advocate and fight for you. And in order to fight for you, they must be armed with all of the information, all of the important facts, everything about your case and everything that you might know about the other side's case. But when they don't have that information, 3 things I'm going to tell you about it. Number 1, you place your attorney in a position to where your attorney cannot fully advocate for you. They can't fully fight for you. They can't fully go to bat for you because they're not equipped to do so. They're not equipped to really fight for you. And then secondly, they're not equipped to fully tell your story. How can they fully tell your story if they don't know the whole story? How can they fully step into your shoes and tell all of the details that might advance your story, all of the talking points that might be compelling to a judge or jury if you haven't armed them with the information? The answer is they can't. And then finally, when you fail to tell your attorney everything, all of the important information, you essentially force your attorney to go in there and fight with his or her arms or hands tied. Because you haven't given them the things that they need to properly fight for you. I mean, see, here's the thing. If you tell your attorney everything, including the bad things, that allows you and the attorney to be creative. That allows the attorney to think about, okay, what's the workaround with this? How do we present this in a better light? What can we do? Are there other facts to where we can focus on them and maybe hide these things or make them less prominent? Or at the very least, it allows the attorney to say, okay, if I were on the other side and this information was known, what would I try to do with that information? And then the attorney then can prepare for that. You know, attorney can say, hey, you know, based upon this, I know that they're going to really focus on this point or this fact. Here's how we can address that. Here's how we can do that. Here's how we could deal with that and still come off in a positive way. But when your attorney is blindsided in court, when you told your attorney one thing and then in the middle of battle, in the middle of a procedure, your attorney is blindsided by something that you sat up there and knew, by something that you could have very well told the attorney. It makes the attorney look bad and unprepared, and it's certainly going to hurt your case. Depending on the facts, it could be fatal to your case. The bottom line is, listen, there are no facts that are so bad that you shouldn't tell the attorney. There are no facts that are so bad that you have to withhold it from the attorney. It's not going to help you. Listen, you got to understand that your attorney's not there to judge you. Your attorney's there to help you. Your attorney's there to advocate for you. So that means that you must tell the attorney everything, the good, the bad, and the ugly, so that you then empower the attorney to take the full narrative of your story and go to battle, advocate for you, fight for you, and to deal with the things that are difficult and to diminish the points that might hurt your case. But if they don't know, they can't go. If they don't have the weapons of warfare, how can they wage war on your behalf? The answer is they can't. At least not as good as they could. At least not to their full capacity. The moral of the story is this: never, ever, 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 ever withhold information from your attorney. I hope that this has been helpful. If you have questions about this, please let me know. Reach out, give me a call. I'd love to hear from you. And until next time, just remember this: if you have to be guilty of anything, be guilty of greatness. Take great care.